Hello and welcome back to the European Times. I'm Elizabeth Carter, and today we're diving into a story that's been simmering for decades: Italy's ongoing legal battle over discrimination against non-national university lecturers, or Lettori as they're known. Now, if you've been following our series, you'll remember last episode we talked about innovation and investment in European higher education. But today, we're looking at a very different side of the university experience: the fight for equal treatment and the long shadow of discrimination. For notice, this series comes to us from Henry Rogers, who teaches English language at La Sapienza University, Rome, and has published extensively on the discrimination issue. So, let's set the scene. Italy has told the European Commission that it's finally ended discrimination against Lettori. This claim was made in a letter to the Commission in October 2024, referencing a ministerial decree from May 2023. According to the Italian government, they've made the necessary settlements to reconstruct the careers of these lecturers, and, in their view, they're now in compliance with EU law. But, as is often the case, the story doesn't end there. Enter FLC CGIL, Italy's largest trade union who, let's be honest, aren't exactly convinced. They, along with the Lettori association asso.cel.l, were invited by the Commission to provide evidence that the majority of former Lettori haven't actually seen their careers reconstructed. And, well, they took up the challenge, launching a national university-by-university census to see what's really happening on the ground. Now, you might be wondering, why is this case still dragging on? I mean, the first infringement case dates back to 2001, and the original legal battles go all the way back to 1989. That's longer than most academic careers. It's a classic example of how government claims and union findings can be worlds apart, and why independent verification is so crucial in these cases. The Commission's role as the so-called guardian of the treaty is being put to the test here, and frankly, the stakes couldn't be higher for the lecturers involved. So, what did the census actually find? Well, the results are pretty stark. Out of 39 universities that participated, only the University of Milan fully settled claims with Lettori, offering uninterrupted career reconstruction from the date of first employment. That's 1 out of 39. In most other universities, either no settlements were made at all, or the settlements were for much less than what Milan offered. And here's the kicker. Many universities used domestic statute of limitations rules to reduce the number of years for which Lettori could claim back pay. So even where there was some movement, it was often partial at best. This isn't just a technicality, it's a real, tangible impact on people's lives and careers. And it's not unique to Italy either. I remember covering a similar dispute in another EU country. Won't name names, but let's just say transparency was a major issue there as well. Universities would claim compliance, but when you dug into the details, you'd find all sorts of creative accounting and legal maneuvering to minimize payouts. It's a pattern we see across Europe. The letter of the law is followed, but the spirit is often left behind. The census data was sent to the Commission in March 2025, and both unions were confident in their findings. But instead of a thorough investigation, the Commission simply passed the data on to Italy and relayed Italy's criticism that the results were too aggregated. The unions, for their part, offered to provide the individual census returns to disprove Italy's claims, but they made it clear they didn't want Italy, with its long record of non-compliance, to be the final judge of the evidence. It's a bit like asking the defendant to rule on their own case, isn't it? This brings us to the heart of the matter: transparency and accountability. The Commission refused to disclose Italy's evidence, citing confidentiality in infringement proceedings. And that's not just a bureaucratic quirk, it's had real consequences. In the 2006 infringement case, Italy avoided hefty daily fines because the Commission didn't have the information needed to challenge Italy's last-minute claims of compliance. If the Lettori had been able to see those depositions, they might have been able to prove that the settlements were never actually made. Instead, the discrimination persisted. Now, Irish MEPs Michael McNamara and Cynthia Neame have stepped in, raising what they call conscience questions to the Commission. McNamara wants the Commission to check, university by university, with the foreign language lecturers themselves to ensure the correct settlements have been made. Neame, meanwhile, is challenging the legality of using domestic statute of limitations to limit back pay, pointing out that the Court of Justice has already ruled such practices are contrary to EU law. So far, the Commission hasn't really addressed these points. Meanwhile, in the Italian Parliament, there are calls for transparency about how the funds set aside for Lettori settlements have actually been spent. The numbers are significant. Over $78 million has supposedly been earmarked since 2017. But the unions say only a fraction has reached the lecturers themselves. If and when the Minister for Universities and Research responds, we might finally get some clarity. So, as we wrap up, it's clear that this isn't just a story about legal technicalities or bureaucratic wrangling. It's about real people, decades of struggle, and the ongoing challenge of holding governments and institutions accountable. We'll be keeping a close eye on the next developments in this case. And as always, we'll bring you the latest right here on the European Times. Thanks for listening, and until next time, take care.